and also fortunate enough to be a Kids Count Steering Committee member and one of the planners of today's call. This is the final webinar in a series of webinars we've been doing on children and immigrant families, designed to support Kids Count grantees around the release of the Race for Results report, which will be coming out soon on October 24th. And we hope that this webinar will be useful also for the partnership members that work on issues affecting children and immigrant families. So welcome all, those who are Kids Count and partnership members, and all who care about children and immigrant families. During this call, we will consider the profound and wide-ranging challenges to immigrant families' economic security. And we're fortunate today to have two speakers, one from the National Immigrant Law Center and one from CLASP. These are two organizations that have recently launched a campaign to address the many policy threats to immigrant children and families. And our speakers today will be Wendy Cervantes from CLASP and Jackie Vimo from the National Immigration Law Center. I'll just briefly introduce Wendy, and then the way we'll work is Wendy will do a brief presentation, and then we'll pause for a moment to ask questions using the question and answer box in the bottom left-hand corner of your screen, moderate those questions. Then I'll briefly introduce Jackie, and then we'll have time for questions as well. So as you're listening, please think of questions to ask, and we'll try to get to as many as we can. So before I turn it over to Wendy, I just want to do a really quick introduction. Wendy is a senior policy analyst at CLASP, where she works to develop and advocate for policies that support low-income immigrants and their families. She's an expert on cross-sector policy issues that impact children of immigrants, including family economics, child welfare, immigration, education, healthcare, and human rights. And as a member of the Child Care and Early Education team, she also focuses on improving access to these programs for children of immigrants and children of color. Prior to joining CLASP, she was VP of Immigration and Children's Rights at First Focus. And she's the proud daughter of Mexican immigrants and holds a master's in Latin American Studies and Political Science from the University of New Mexico, and a bachelor's in Communications from the University of South Carolina. With that brief introduction, I'll turn it over to Wendy Cervantes.
Thank you, Stephanie, and just because I don't want my alma mater to get upset, that's the University of Southern California. So thank you, and thanks to all for joining us today. As mentioned, I am here today on behalf of the Center for Law and Social Policy, and we're a national, nonpartisan anti-poverty organization. Oh, let me move that slide over. We're a national, nonpartisan anti-poverty organization that advocates for and helps implement federal and state policies that work for low-income communities, including low-income immigrant families. And as mentioned, we're also very excited to be partnering with the National Immigration Law Center on a new campaign that my co-presenter will be discussing in more detail later. So today I'm going to provide an overview of how immigration policies at the state and federal level impact children, including an overview of recent policy changes as well as upcoming opportunities and challenges. I'll also wrap up with how children's advocates can help push for a more kid-friendly immigration policy agenda. So starting off, I wanted to make sure that we all have a baseline understanding of who children of immigrants are. I know you've recently had a data webinar which covered these categories of children in detail. So just to review, today I'll be talking about children in mixed status families. There's more than 5 million children in the U.S. who live in a mixed status family with at least one unauthorized parent, and the vast majority of these kids are U.S. citizens. I'll also be talking about undocumented children. There's less than 1 million undocumented children under the age of 18 estimated to be living in the U.S. These children are also often referred to as dreamers. I'll also be talking about unaccompanied children. These are children who arrive to the U.S. alone and have no parent or legal guardian to provide for their care or custody. There's been a significant increase in the number of unaccompanied children entering the U.S. in recent years. In 2014, there was a high of 68,000 children entering the U.S., and more than 170,000 children have been placed with sponsors around the country since 2014. These are primarily children fleeing violence and instability in the northern triangle of Central America, which is made up of Guatemala, Honduras, and El Salvador, although unaccompanied children do come from around the world. So first, I think it's important to recognize that immigration policies have historically been developed with little to no regard to children, even though it's kids that often face the most significant consequences. Even the policies that are directly related to children often fail to consider their best interests. So many policies that we think of as anti-immigrant in nature are also often anti-children. Children and immigrant families also have long faced unique challenges to their economic security. They're more likely to be low income, uninsured, live in food insecure households, and face barriers in accessing public benefits and other public programs such as early childhood programs, particularly so for children living with at least one unauthorized parent. Some of the barriers facing immigrant children and families include the ones listed here, the lack of awareness regarding availability of programs, which is a challenge for a lot of low-income children, but in particular for children and immigrant families due to things like language and cultural barriers. There's also very confusing immigrant eligibility rules for various public programs, and these are rules that are confusing not just for families, but for service providers as well. There's also a lot of immigration-related concerns, including fear of immigration enforcement, and historically there's also been a lack of sufficient training for frontline workers. So as I mentioned, immigrant eligibility rules for public benefits are very restrictive as well as complex and confusing. There have been several major pieces of legislation over the past 2 decades that have had implications for immigrants' access to benefits, the most significant by far being the 1996 Immigration and Welfare Reform Laws. Before 1996, lawfully present immigrants were able to access federal means-tested programs in the same way as U.S. citizens, granted they met all the general requirements. That all changed with the 1996 laws. The 1996 Welfare Reform Law, known as PWRA, created 2 categories of immigrant benefit classifications, qualified and not qualified. Qualified immigrants include lawfully permanent residents or green card holders, refugees, Cuban and Haitian entrants, and trafficking survivors and victims of abuse. Unqualified immigrants include all other non-citizens as well as undocumented immigrants. So what the law did essentially was it now also requires qualified immigrants to wait 5 years before they can become eligible for certain federal means-tested programs such as Medicaid, except for emergency Medicaid, CHIP, TANF, SNAP, and SSI. It's important to note, however, that subsequent legislation restored some of the eligibility that was lost under the 1996 laws, specifically for children and pregnant women. For example, the Children's Health Insurance Program Reauthorization Act in 2009 provided states with the option to waive the 5-year bar for lawfully residing children and pregnant women, an option which more than half the states have chosen to take. In fact, this past year, Nevada and Arkansas were the newest states to join those who have taken up this option. Similarly, legislation in 2002 also restored eligibility for SNAP to lawfully present children by also waiving the 5-year bar for children who qualify. This is a map which shows the states that have opted to waive the 5-year bar for lawfully present immigrant children. Those are the blue states. I should note that Arkansas, that just recently passed a law, that law does not go into effect until 2018, so that state will become blue shortly. I also wanted to point out that several states, those that are in orange here, have also opted to cover all children in their state regardless of immigration status using state funds. So moving on from public benefits, I also wanted to flag some of the existing civil rights protections for immigrant children and youth in education settings. So first of all, one moment, I need to take a drink of water. I was just getting over a cold. So first of all, thanks to a 1982 Supreme Court ruling known as Plyler v. Doe, all children in the U.S., regardless of immigration status, are entitled to a basic K-12 education, and thus also have access to school-based nutrition programs such as the National School Lunch Program. However, it's important to note that the Plyler v. Doe ruling does not extend to higher education, which is why undocumented youth have historically faced significant challenges to pursuing their education beyond high school. Similarly, the Plyler ruling does not automatically extend to early childhood education programs where eligibility for children and immigrant families varies, and I'll cover this in more detail on the next slide. Under current civil rights and privacy laws, it's also important to note that schools are also prohibited from various forms of discrimination, including on the basis of national origin, and they also cannot bar a child from enrolling in school for lack of certain documentation, such as a Social Security card or birth certificate. In the early childhood context, the rules on immigrant eligibility are based on funding streams, as well as the settings in which services are delivered. So it's important to know the funding source to know whether restrictions apply. So Head Start, for example, is defined as an educational benefit, so it's open to all children regardless of immigration status. And likewise, child care that's subject to Head Start performance standards or operating with combined child care Head Start funding is also exempt from restrictions. Programs that fall under the Child Care and Development Block Grant, or CCDBG, are restricted to qualified immigrants, which I covered earlier, in most circumstances. But it's important to note that the eligibility is based on the child's status, not the parents. And thus most children are eligible because they're U.S. citizens or lawful permanent residents. There are some exceptions, however. For example, Head Start collaborations and child care subject to public educational standards are exempt from immigrant restrictions, and likewise, pre-K falls under public educational standards and therefore is also exempt from immigrant restrictions in most circumstances. If this seems confusing and complicated, it is, so don't feel alone. You don't have to memorize this, but it goes to show how confusing this landscape can be to navigate for families who may end up foregoing available child care and early education opportunities that they're actually eligible for. Looking at immigration policies more broadly, in particular those that are less friendly to immigrants. As I mentioned earlier, these policies can have both a direct and indirect impact on a children's development. First, the research tells us that the stress related to unauthorized status can have a long-term harm on a child's development, including the constant fear of deportation and the stressors of a parent's unauthorized status, or a child's unauthorized status for that matter. And these can lead to, when a parent's unauthorized, that can lead to increased stress for themselves, which can then be passed on to children. Second, immigration enforcement puts families at risk of separation, and whenever a parent is deported, a child is subjected to trauma, whether that child is left behind with another parent, family member, or friend, whether the parent chooses to take a child with them, and often when this happens, it's in the case of very young children, many of whom are U.S. citizens and have never been outside the country. And then, of course, there are also extreme cases in which a child may enter foster care as a result of a parent's deportation. And once again, I'll just keep saying this, policies that restrict access to critical health and nutrition assistance and other public programs are also obviously very harmful to a child's development. And finally, we know that U.S. policies related to unaccompanied and other asylum-seeking children also have historically fallen short. And in fact, in recent years, we've seen a troubling move towards a more enforcement-heavy deterrence focused policy approach rather than one focused on protecting children. In fact, the White House principles just introduced by the administration on Sunday include some of the most extreme cuts, like rollbacks and protections for asylum-seeking children that we've seen to date. So moving on to the current policy landscape. As many of you are well aware, immigrant families have been subject to one attack after another since President Trump's inauguration. Just this past Sunday, as I mentioned, the administration released a troubling set of immigration principles which further threaten to undermine the safety and well-being of immigrant and refugee families, such as proposed measures to cut overall immigration to the U.S. and penalize localities that choose not to collaborate with immigration officials. And just over a month ago, the Trump administration announced the end of the Deferred Action for Childhood Arrivals program, or DACA, a program that was introduced in 2012 by President Obama that provides 2 years of reprieve from deportation and a work permit to certain young people who came to the U.S. as children, also known as Dreamers. Since its introduction, the program has provided more than 800,000 young people with the ability to work, further their education, and better support their families. The decision to end DACA came after months of mixed messages from the administration regarding the future of the program, as well as a letter from the Texas Attorney General and 9 other states threatening a lawsuit if DACA was not rescinded. This devastating decision has significant implications, which I'll cover in more detail shortly. Then just within his first week as president, Trump issued 2 very damaging immigration executive orders which have intensified immigration enforcement actions across the country. For example, one of the orders essentially makes any individual without authorization a priority for removal. And it also calls for massive increases in the number of immigration agents and expands immigrant detention. As a result, we've seen many parents of U.S. citizen children and other long-term residents now being deported who previously would not have been considered enforcement priorities. And then finally, earlier this year, there was also a lot of concern amongst service providers and immigrants alike, including those that are lawfully present, in response to a leaked draft executive order known as the Public Charge EO, which would seek to rewrite long-standing rules around who can enter or stay in the country based on their risk of what is becoming known of what's known as a public charge. My co-presenter, Jackie, will cover this draft order in more detail. So I just wanted to flag that it's one of many threats that we've seen like this in addition to other bills in Congress and other administrative proposals. And so I wanted to take a closer look at the direct impact on U.S. citizen and other lawfully present children who live in mixed status families. So first of all of these children are now at increased risk of being separated from a parent. Under the previous administration, in addition to the fact that most parents and other longtime residents weren't considered enforcement priorities, they were also often eligible for something that's known as prosecutorial discretion because of the hardship it would cause to their children should they be deported or detained. But now we've seen an increase in the number of immigrants who are showing up to their regular check-ins with ICE only to then be detained and deported. And then in addition to and I think it's important to note in particular that given this recent announcement regarding DACA, that more than 25% of DACA recipients are parents of young U.S. citizen children. So the loss of DACA status will not only impact the recipients themselves, but also their families. It's also, as I mentioned earlier, in addition to the harm of being separated from a parent, we also know that the fear alone of possible separation from a parent can create persistent stress in children, also known as toxic stress, which research tells us can be very harmful to a child's development. And then it's important to note that the increase in immigration enforcement has also created a climate of fear, making immigrant parents reluctant of carrying out their basic everyday activities, including just sending their kids to school, much less signing their kids up for nutrition or health care assistance. And in fact, CLASP has been interviewing child care and early education providers around the country to get a better understanding of how these immigration policies are impacting young children and immigrant families. And in our interviews, it's become very clear that immigrant families are changing the way they do things, changing the way they plan how to go to the grocery even, and there has been a drop in participation in a lot of these programs because of concerns about whether ICE will show up to a child care program or how any information they provide to the program might be used against them. And so you can imagine then that this enforcement-heavy environment has also created real concerns for health and human service providers, and they're also asking a lot of the same questions. Will ICE show up at their door? Will they be asked to share information about their clients? So there's a lot of uncertainty and questions, even among service providers, about how they protect the children and families that they're serving. And finally, the anti-immigrant climate in communities and schools is having a damaging effect on relationships between students, with accounts of increased bullying as well as increased shame about their parents' immigration status or their own immigrant heritage. This is something that we heard a lot in the interviews that we did as well. I also quickly just wanted to touch on the specific threats to unaccompanied children. For example, the enforcement orders that were introduced in January, as I mentioned, they seek to weaken protections for unaccompanied children and subject them to faster deportations, and also subject their parents to deportation and possible criminal charges. And the White House principles that just came out this past week would actually go further by also changing the definition of what it is to be an unaccompanied minor and stripping those who no longer qualify for the definition of a lot of the protections that they would have been entitled to. The proposed principles call for the dismantling of critical protections that have been created under the Trafficking Victims Protection Act, as well as what's known as the Flores Settlement, which means that children will be subject to longer periods in detention, most likely in worse conditions, and the principles also seek to make it more difficult for immigrant children who have been subject to abuse or neglect to qualify for immigration relief known as Special Immigrant Juvenile Status, or SIJS. And these threats to unaccompanied children are significant, not just because of the increasing numbers of kids who've been coming to the U.S., but because research also consistently shows that these are children who have already undergone significant trauma in their home countries as well as on their journey to the U.S. In fact, researchers such as Dr. Zayas out of the UT Austin School of Social Work has often referred to the experiences of unaccompanied children as trauma upon trauma upon trauma. And he's referring to the pre-migration trauma, what children go through already in their home country before making the trip to the U.S., the in-transit trauma, which occurs during a child's journey alone to the U.S., and then the post-migration trauma, which is associated with just trying to transition to a new country, a new school, and a new family, all with very little supports and all while having to navigate the complicated immigration system. So looking a little closer at DACA termination, this slide just kind of provides an overview of what DACA termination means and what is how this rescission of DACA will be rolled out. Essentially, USCIS will phase out the program through March 5th of 2018. As of September 5th, there's no first-time applications being accepted. Current DACA recipients will be able to maintain their status until their 2-year DACA period expires, and those who were eligible for renewal between September 5th and March 5th were able to renew, but they only had 30 days to renew from the date of the announcement. So all of those renewal applications had to have been accepted by USCIS as of October 5th, a deadline which, as you know, has just passed. And so, as I mentioned, there's about 800,000 DACA recipients to date who are now going to lose their status eventually. And I mentioned that of these 8,000, that there's about 25% who are parents. I also think it's important to recognize that many DACA beneficiaries are also teachers in our early education and K-12 schools. So it's also going to be a loss to those students when those teachers can no longer continue to teach. It's also important to note that there's more than 200,000 little dreamers, as we call them, who are waiting to turn 15 in order to qualify for the DACA program, who will now no longer be able to apply for relief under the program. And for those who are going to lose their DACA, what that means essentially is that they're going to lose their employment, possibly their health insurance through their employer, and other benefits for DACA recipients, which my co-presenter will discuss in more detail shortly. So I don't want to just focus on bad news. I want to talk about some opportunities as well as some more threats, and also what you can do. So I want to flag some federal legislation to keep an eye out for. So given the urgency to resolve the predicament facing dreamers following the rescission of DACA, several bills have been introduced to provide a solution. I've listed all of the existing bills here, and I'm happy to answer questions about them. But I do want to flag that the DREAM Act of 2017 is the only bipartisan legislation that most comprehensively encompasses the diversity and needs of the Dreamer population. It would provide a pathway to citizenship for Dreamers who meet the bill's education, military, or employment requirements, and also includes a hardship exception for those who may not be able to meet the requirements, such as those who are raising children. Some of the other bills, like the SUCCEED Act or the Recognizing American Children, or RAC Act, have much longer pathways to citizenship, and they also leave out many Dreamers because of overly restrictive age and date of entry requirements, and some of them also create some unrealistic hurdles to be able to meet the requirements in order to get on the pathway to citizenship. And then there's a few other bills relevant to children that I wanted to also highlight. One is the Protecting Sensitive Locations Act, which is a bill that would try to codify an existing policy, which I'll cover in more detail on the next slide. There's also the Fair Day in Court Kids Act, which would provide government-funded legal representation for unaccompanied children so they don't have to face immigration court alone. There's the Help Separated Children Act and Help Separated Families Act, two bills that are expected to be introduced in the Senate and the House, which are focused specifically on mitigating the harm to children that are impacted by immigration enforcement, as well as to increase the chances of children who enter the child welfare system as a result of immigration enforcement, or who have a detained or deported parent, to increase their chances of reunifying with their parent. And then, on the bad side, there's also it's important to keep an eye out for ongoing threats to child tax credit eligibility for immigrants who file their taxes using an individual taxpayer identification number. And so I quickly wanted to highlight the existing sensitive locations policy, which is actually a policy under the Department of Homeland Security, which prohibits Immigration and Customs Enforcement, as well as Customs and Border Patrol, from carrying out immigration enforcement actions in certain places that are considered sensitive. And this includes hospitals, schools, places of worship, funerals, weddings, and public demonstrations. Under the hospitals and schools category, it's important to note that that also includes health clinics and community health centers, and under schools, that also includes child care and early education programs and after-school programs. And this has been, we've learned that in our interviews with child care and early education providers, that there's a lot of agencies that are serving families who don't know about the existence of this policy. And we're also incredibly concerned that this policy could be rescinded at some point in the future. And it's incredibly important because by having this policy in place, we know that it helps families feel safe to do things like access health care, take their kids to the doctor, take their kids to school. And it's one of the areas that through the campaign that we're working on with NILC, we're really trying to work towards protecting. And the bill that I mentioned earlier, the Protecting Sensitive Locations Act, would basically seek to not only codify this existing policy into legislation, but also expand it to include places like courthouses. And then I also just wanted to flag that legislative efforts at the state level are also incredibly important. So, I flagged earlier the number of states who have chosen to cover lawfully present children and also other children regardless of status. And so there continue to be efforts to expand health coverage for immigrant children at the state level. There's also historically been tuition equity bills that have been proposed and passed in also nearly half the states to provide access to in-state tuition for undocumented students in their state. And there's also been bills on the other side to bar undocumented students from accessing in-state tuition, and in some states like South Carolina and Georgia, barring immigrant students from enrolling in public universities altogether. We've also seen bills, like in California, to provide legal counsel for unaccompanied children through state funds. We've also seen legislation, once again in California, that looks at, that focuses particularly on the child welfare system and creating policies to ensure that children are able to reunify with detained or deported parents. And that was the Reuniting Immigrant Families Act, which was passed in 2012 in California. And then we've also seen on the negative side, in this past year specifically, anti-immigrant legislation like SB 4 in Texas, which would increase collaboration with local law enforcement to carry out immigration operations in Texas. And finally, I just wanted, before I pass it on to Jackie, I just wanted to highlight some of the ways that children's advocates can also help advocate for policies that promote the well-being of children and immigrant families. And the first is to help document the impact to children and immigrant families at the state level. And I think this is incredibly important, especially given the recent changes in policy to tell that story and to not only influence policy, but also to influence public opinion. Of course, there's always the importance of reaching out to elected officials and to help support local efforts to pass pro-immigrant legislation and push back against harmful proposals. We've seen a lot of really great examples of when children's advocates can partner with immigrant rights organizations and pass legislation like expanding health care coverage for children. I think children's advocates have a really strong voice in battles like that. And then given the role that children's advocacy groups often have, they can encourage organizations who serve children and families to adopt policies that would help promote access to programs for children, such as children and immigrant families, such as confidentiality policies regarding information and making sure that agencies are aware of the sensitive locations memo and whether they qualify for it. And also, I think it's critically important to help educate other children's advocates and children serving organizations in the state. I think even just documenting who are children of immigrants in your state, doing a demographic profile, assessing the threats and opportunities that exist in your particular state. And I think it can be helpful to help. I think it really helps when it's a children's group to help simplify this. I think immigration policy can sometimes be really intimidating, and it's hard to make those connections to how it impacts kids. But I think using that any children's advocacy organization that's really looking to improve outcomes for children or to help reduce disparities can integrate an immigration lens and help and really help make that case for why children of immigrants are a critical population and why we need to improve policies for them as well. So with that, I'm going to wrap it up and pass it over to my co-presenter, Jackie. This is my contact information for anyone who has additional questions, and I'm going to leave it there.
Great. Thank you, Wendy. This is Stephanie again. I just wanted to give people a chance if they had a couple of burning questions. We have a few minutes between presenters to ask questions of Wendy. If there aren't any questions, I'll give people a few minutes to type them into the chat box. I have a couple questions that I might just use to get the conversation started. One question I had is that with the current situation around CHIP reauthorization, are there particular threats to health coverage for immigrant children who may be currently protected under state health coverage that might be affected by the delays in CHIP reauthorization we should know about?
Well, that's a great question. And I mean, unfortunately, the answer is yes, of course, because right now all children who are currently covered by CHIP are at risk of losing coverage when their state runs out of funding. And so I think getting CHIP reauthorized is as important for immigrant children as it is for all other kids. Because when a state runs out of funding for any of the kids, that's going to impact immigrant kids as well.
Great. I have one more quick question, and I really encourage people to type questions into the chat box either now or at the end so we can ask questions of either of the speakers. But the other question I have is, here in Rhode Island, we've been hearing a lot of anecdotal information about high school students who are perhaps unauthorized themselves, or perhaps they're part of that 5 million group where they have parents who are unauthorized, who are nervous about filling out the FAFSA application. It's particularly problematic in Rhode Island, where our state recently passed a free college bill that would allow children to get 2 years of free college at our community college, but we're worried that students may be nervous about filling out the FAFSA and also then gaining access to that program because of concerns about immigration enforcement around their parents, given the current federal climate.
Right. I mean, and that's, a concern we're hearing across the board with lots of types of different applications that folks have to fill out. I will reiterate that there still remain very strong privacy protections for immigrants and for citizens, and so we are encouraging folks to apply for things like fill out forms like the FAFSA, because that's just incredibly important, and because the privacy protections that currently exist, and since they're not necessarily required to provide information regarding that explicitly state their parent status, that folks should feel safe doing that. I don't know if Jackie maybe wants to add anything else to that, but she can.
I mean, just to say that there are strong protections in place, and the kind of guiding principle is that, legally and kind of in practice, very unlikely that what the law does allow right now is if you have a warrant for a specific type of information where you're looking for a specific person, honestly, under the Patriot Act, even prior to any of these immigration things, the federal government can get access to that information. However, in most instances across agencies, be they health agencies, be they educational agencies, so forth, the kind of doing a mass sort of expedition where they just kind of harvest all the information would be almost impossible legally in most cases. So I think that's the important thing to know, that really there isn't a risk as much of all people in the FAFSA database getting pulled out. It's the only kind of legal loophole is if they're looking for someone in particular.
Great. So a couple of quick questions came in. Let's see if we can get at least one of them addressed now. We might have to leave the other one until the end. One question came in from Amy in Kentucky is there any benefit or wisdom in very red states of not lumping all Dreamers together and instead discussing specific needs of those with U.S. citizen children versus those without children of their own, but perhaps with one citizen parent? So talking about the different groups, different.
So that's an interesting question. So I think I understand that's a question of strategy, and I think it is important to highlight the specific challenges that are facing certain Dreamers, such as those who have U.S. citizen children, and how that would impact their families. But I also think it's really important to emphasize the importance of protecting all of these young people who came as children and who have grown up here and who have offered their information to the government. And so I think the risk of potentially trying to separate them out is to create this division that might actually be harmful when we should be making the case for covering everyone who is a Dreamer and who should have the opportunity to remain in this country and continue to contribute to our economy.
Great. Well, we're getting a lot of interesting questions. Maybe I'll try to ask one more now, and then we'll leave the other one for the end. Hopefully other people will have other good questions. Dee Dee Hill asked, are there states, cities, communities that have implemented programs that aid immigrant families to access the essential services to which they are entitled, to counter the fear that is causing so many immigrant families from avoiding all contacts with government agencies? So she's looking for those good examples of, where there are good practices in cities and states and communities that maybe address some of those fears and make sure immigrants get access to services for which they're entitled.
Well, her question will definitely be answered because I know Jackie is going to cover that in her presentation.
Great. Well, then maybe that's the time to hand it over. So I will do a really quick introduction of Jackie so we can get on to the next presentation. So Jackie Vimo is a policy analyst for the National Immigration Law Center, which is a national organization that engages in policy analysis, litigation, education, and advocacy to defend and advance the rights and opportunities of low-income immigrants and their families. She's been working for almost 2 decades on a broad range of public policy issues in California, New York, and Argentina. Prior to her time at the National Immigration Law Center, she was the Director of Advocacy at the New York Immigration Coalition and has taught political science at the Political Science Department at the City College of New York and at the New School University, and is currently a PhD candidate in politics at the New School for Social Research. I'll turn it over to Jackie.
Great, thank you. So I'm going to talk a little bit kind of about the policy threats, and unfortunately I have more questions than answers, or rather possible directions, but we don't really know where this administration is heading. I don't think many people do, maybe not even the administration itself. But I'm going to talk a little bit about what some of the threats are that are coming up, specifically related to immigrant families accessing benefits. So first of all, when the administration came into office back in January, I don't know how many, I'm going to go over this because it's emblematic of the broader threat that we see coming from the administration. And again, this is something that we don't know if it's going to be signed, and I'm going to talk a little bit about that. But really we know that there is going to be a strong impulse, and that there has been since January, since this administration first came into office, to really go after issues of public charge and sponsor liability. So I'm going to talk a little bit about what that is. So back in January 2017, there were a series of executive orders that were leaked to Vox.com and the Washington Post. Of those orders, all but this public charge executive order have already been signed into law or enacted in some way, shape, or form. So the other ones included ending the DACA program, H-1B reforms, and interior enforcement, directing the DHS to pursue an aggressive campaign of interior enforcement without regard to the priority setting of the Obama administration. So given that it's the last one standing, we do see that it's very likely that it will be signed, since the other ones were over time. And if not signed, implemented in some way, shape, or form. We also have heard rumors that there is a copy of a memo or some kind of a rule on the desk of someone at USCIS, so that there is active movement on this. So it may not come in the form of an executive order. That said, so I'm going to tell you what that order is if you don't know. Just want to reiterate that laws and policies about immigrants and public benefits have not changed under the Trump administration. And as I was mentioning earlier, federal and state laws that protect the privacy of people who access programs remain in place. You can't they need to change statutes for things like IRS, WIC, all these agencies have statutory protections, so President Trump can't just eliminate them through executive order. Congress would have to pass something. So let me just kind of quickly, for those of you who don't know what public charge is, just mention that public charge is really the kind of central crux that we've seen, and we know that there are folks within the administration, in particular Stephen Miller, who has been had a lifelong commitment to trying to deprive immigrants of access to benefits, through potentially the avenue of public charge. So what is public charge? Public charge is a term within immigration law, which is a determination based on if someone is or is likely to become dependent on the government for basic assistance. This has been in our immigration law for over a century. The public charge assessment, I think that one of the most important things to know about public charges is that it's a determination that about whether or not you're allowed to come in or whether you're allowed to become a green card holder, and that's when the determination happens. That assessment is a forward-looking determination. So there has to be a determination of whether or not you are a public charge, and the assessment is made at the moment you either apply to enter the United States or at the moment that you're applying to adjust status to become a legal permanent resident, a lawful permanent resident, a green card holder, but does not apply when you're applying to become a U.S. citizen. Frankly, deportation based on public charge is rare. It's really almost unheard of. In my experience of doing this work, the only cases I've heard where public charge has sort of had real significant impacts have been cases when people on tourist visas who are entering and leaving the country came into the United States on a tourist visa, gave birth, maybe racked up a $150,000 bill at the hospital, left the country again, and then reapplied to get a tourist visa to come back. I think one of the most important things to know is that in that situation, that individual was given the opportunity to repay that debt in order to come back. Obviously, most people don't have enough money to pay for most medical services sort of wholesale at the ticket cost the insurance covers. So that is an issue. But one of the things, again, to mention also is that public charge is not it's only one factor in considering someone's immigration case. It's not that you used a benefit once and you're officially done, you can't be admitted into the country, and you can't get a green card. The determination of public charge is made based on a totality of circumstances. So a good lawyer can paper up your case, can really make a good case that, okay, maybe use unemployment and maybe use this benefit, but as a whole, you don't constitute a public charge, and there's all these other factors like familial ties and so forth. So all of that said, I also think it's important to note that for years and years and years, the only two benefits that are subject to public charge determination are cash assistance for income maintenance and institutionalization for long-term care. So I just used some examples like unemployment or this and that, or talking about getting access to health care, or maybe using WIC or some program like that. Those do not count for public charge under present law. The only two benefits that raise public charge concerns are cash and long-term care. So cash and care, that's it, and long-term care. And so I just want to reiterate that there's a lot of bad information going on out there, and that I've been hearing. I mean, I've even heard U.S. citizens who have green card holder spouses going off of cancer treatments because they were worried that it would impact their spouse. I mean, which is that's actually just not. That is no basis in law and is not actually kind of rational. So I think it's important to reiterate that there's a lot of misinformation out there. The second piece is sponsor liability. So U.S. citizens and green card holders can sign an affidavit of support to become a sponsor of a person, usually a relative, when they're applying for a green card. Family-based immigrants are required to have a sponsor. And basically what the sponsor liability means is that affidavit of support that you sign authorizes the government to pursue reimbursement from the sponsor if immigrants use certain federal benefits while the affidavit of support is in effect. So similar to the limitations on public charge, there are only 5 programs that give benefit to sponsor liability concerns. That's SSI, TANF, cash assistance, SNAP or food stamps, non-emergency Medicaid, and CHIP. Those are the only 5. So again, public charge is if you receive cash or long-term care, and sponsor liability is only SSI, TANF, SNAP, non-emergency Medicaid, and CHIP. Now, again, we don't have, in practice, government agencies have not pursued sponsors. And there have been some cases in New York a few years back. I was involved in a case where the city was trying to pursue sponsors through the Human Resources Administration. Legal aid was involved. There was litigation. They pushed back and haven't really done it. But for the most part, they're not really going after sponsors. But I think there is quite a bit of confusion and concern among people who have sponsored their family members. Am I going to have to pay back benefits? Okay, so quickly, just what the leaked executive order does and where we think. So right now, the kind of scope of what public charge and sponsor liability, are quite small. and generally not a concern for either most immigrants or their sponsors. But we know that the Trump administration has leaked this executive order, which does three things. One, it seeks to further restrict benefit eligibility. Two, it changes how public charge is determined. And three, it actually directs states to aggressively pursue sponsor liability. So what does that mean? Restrict benefits. Right now, we have this 5-year bar mentioned, that applies to a vast array of critical public benefits for the first 5 years that you're in green card status. But that doesn't include everything. Under this leaked executive order, they would apply that to a vast array of different benefits. The second piece, which is perhaps the most concerning, is that they would expand public benefits beyond the current 2 benefits right now that count for public charge, cash and long-term care, to include any and all public benefits for which eligibility or amount is determined in any way on the basis of income, resources, or financial need. What does that mean? That means it would include potentially, what are all the programs that their eligibility is determined by income or resource tests. So that would be a Pell Grant potentially, or WIC, or any kind of sort of benefit. And this is very, very troubling. We don't know though how it will be implemented. We know that they are looking to expand public charge beyond cash and long-term care. We don't know if it will include everything, and the other thing we don't know is whether it will apply to state and local funded benefits. So that's a big question. The sponsor liability, again, similarly, the leaked order seeks to expand the benefits subject to sponsor liability to all public benefits for which eligibility is determined on basis of income, resources, or need. Again, does that mean, you sponsor someone and, their kid goes to school and gets a Pell Grant, and you have to pay back that Pell Grant? We don't know. Again, but it would be a change in pursuing sponsors to reimburse the government for any of the benefits that their sponsored immigrants use. Okay, so again, we don't know that if the executive order is going to be released. As I mentioned, we've heard that there's some draft of it at USCIS. I think one of the things that is important to just emphasize, and that I always emphasize when I talk about this, is, as I said earlier, some people are voluntarily disenrolling. We're working with our research working group, which I'll talk about in a second, to try and get a handle on exactly how the Trump administration and the new climate is impacting immigrant access to benefits and immigrant health and welfare. We do know that folks are disenrolling from benefit programs and asking to be taken off the rolls. This actually doesn't make any sense, because if you're already on the rolls, A, from the point of view of if you're worried about your data, they already have it, and 2, you've already accessed the benefit. So it doesn't make any sense to get off of a program if you've already been using it. And we know that people around are spreading a lot of misinformation, and I think that in many ways the executive order didn't need to be signed to do what the Trump administration wanted it to do. Simply by spreading fear and confusion in communities, people have taken themselves out of the benefits that they need to be healthy and strong, and that they're currently entitled to under the law. So I think that it's very important that we, all of us who sort of are talking about these issues, maintain a clear message that it hasn't changed. Otherwise, we are doing the job of trying to deny immigrants access to health and other benefits. So 2 other things that are on the horizon. One, we're definitely seeing that the President Trump's proposed budget, which came out in May, is looking to restrict eligibility to the child tax credit and also to the earned income tax credit to only people who have work-authorized Social Security numbers. So currently, the child tax credit is actually available to anyone who has an ITIN. You don't have to prove work authorization. You don't have to have a Social Security number. It's a really important tool for families where there are children to help them make ends meet. The EITC already requires the filer provide an ITIN, but the current budget proposal would require that both the taxpayer parent and the qualifying children will also have to have a Social Security number. So that would be a change for both the EITC and the child tax credit. There's also a number of pieces of legislation that have been introduced. Representative Messer has introduced quite a few over the years, and to require that a Social Security number be provided when claiming the child tax credit. And it's something that we've been hearing a lot about on the Hill with the topic of tax reform. Okay, so then the next piece, again, is DACA termination. So as folks might know, NILC, we're currently have litigation sort of that is trying to stop the termination of DACA, and are working with attorney generals from around the country on a legal strategy. And obviously there are bills floating, DREAM Act and others in Congress, that hopefully will not lead to the termination of DACA. But what happens for those people who are documented? Again, as Wendy was talking about this, if it does be terminated, one is they'll lose their work authorization, so that's going to be huge. Two, they will lose access to health care in most cases. Now, that doesn't mean that states and localities can't figure out ways to provide health care. And there's also questions about whether or not, if you have DACA, you would need PRU-Call, which is still a status in certain states that have this category in places like Massachusetts, New York, and California. With regards to taxes, our current assessment is when you have an ITIN and you get a Social Security number, that ITIN is no longer valid for the rest of your life. So you are stuck with that Social Security number. That is yours to keep. It is almost impossible to get a new Social Security number. But there are several types of Social Security numbers. Some of them are called unrestricted, and some of them are restricted. Now, the types of Social Security numbers that were given to DACA beneficiaries say on the card, valid only with work authorization, valid only with DHS approval. So, problem being that the Social Security number itself is valid, but the Social Security number does not communicate that that person has work authorization. So what does that mean from the point of view of filing taxes? Now, documented individuals, if they do lose their DACA status and when their DACA status does expire, should file taxes with their new Social Security number. They shouldn't go back to using ITINs, and they shouldn't be committing sort of fraud using someone else's Social Security number. And unfortunately, even though the statute says that they should be able to claim the EITC, the Earned Income Tax Credit, the IRS interpretation is that if you have a restricted Social Security number and that restriction requires work authorization, that you are not eligible to claim the EITC. So that's going to be devastating for many documented people who have been claiming the EITC and who have been eligible. Obviously, this could have an impact on people's access to higher education, and perhaps the most concerning is that it makes them, losing DACA means they are no longer protected from deportation. Just quickly responding to threats, again, want to emphasize that there are extensive protections under the law for people's confidential data, Section 6103 of the U.S. Tax Code. There's guidance from various federal agencies that limit inquiries into state and citizenship and immigration status. SNAP, WIC, Medicaid, all these programs all have confidentiality protections. So one is really so what can be done? So I'm moving into sort of just for the next minute, and then we can go back to questions. What can be done? One is simply that states and local agencies and even nonprofits should really be aware of confidentiality laws. We have a letter that informs local officials of what those confidentiality laws are. I'm happy to share that with folks. And that they could implement their own confidentiality procedures. And one of the things that we think is most troubling is many state agencies don't know that they can actually refuse requests from the federal government. So if a federal agency calls your agency and says, I want this data, you can say, no, that data, you don't actually have a right to that data. So that's really important. And we're also encouraging folks not to keep unnecessary information. If you don't need a Social Security number to give someone a particular benefit, don't keep it. And then finally, next one. The other, it's not moving. Is it moving? It's not showing the next slide. I don't know why, but okay. I'm not sure why it's not showing the next slide. There we go. So again, one of the things that we've seen that states and localities have done is the New York City Health and Hospitals Corporation, San Francisco Department of Human Services, in LA, the Department of Social Services have all issued messages for the public and for consumers to let them know that they are going to respect their confidentiality. And I think that those kind of public messages are really crucial to giving people a sense of security. We don't have hard kind of data on this, but what I've seen anecdotally is that in areas where the localities are putting out messages like this, you're not seeing drops in immigrant access to benefits and healthcare. Again, so I think there's all numbers of things that states and localities can do. There are state laws and policies. You could just copy every single law that California passed, including last week, and really do public education about what those laws are and that nothing has changed. And finally, if you're hearing stories about the harm that's coming from this, please document them and send them to, oh my gosh, send them to us at the Protecting Immigrant Families campaign. So finally, I forgot we had that last piece. I'll be very fast. CLASP and NELC have launched a very exciting campaign called the Protecting Immigrant Families in Advancing Our Future campaign. It is our campaign to basically, under this new climate, to try and defend against new threats to immigrant families and also to lay the foundation for a more public, productive national dialogue about our immigrant tradition and our country's future. The vision of the Protecting Immigrant Families campaign is a nation where we're all truly equal, immigration is recognized as a strength, and no one in America is denied the essentials of life because of where they were born. And again, the purpose is we are bringing folks together to protect and defend access to health care, nutrition programs, public services, economic supports for immigrants and their families at the local, state, and federal levels. Just quickly, the work of the campaign is we're building a network. We're going to create united public opposition. We're going to be doing public policy advocacy, research, and work on communication strategies. And these are the 5 work groups that we've already launched. Federal advocacy work group that's really focused on Hill work, policy and legal analysis, research, communication, and an education mobilization. So united together, we can try and fight back these threats to immigrant access and threats to public charge and sponsor liability. If you would like to be involved, I actually should have added this to the slide. We have a new way to sign up. You can either email me at publiccharge@nilc.org or at vmo@nilc.org, and I'm happy to sign you up to the new listserv.
Great. Well, thank you, Jackie. You were very fast and provided a lot of great information, so I'm sure there will be questions. And I really appreciate you especially answering the question posed earlier about models in states and cities that have implemented ways to make sure that immigrant families have access to the services that they're entitled, the examples in New York and San Francisco and some of the laws you talked about in California. I just wanted to give you a moment if you wanted to expand upon that, since that was a specific question before I moved on to other questions.
Right. So, I mean, I think that absolutely, just quickly, that, putting out notices and establishing confidentiality policies, I think they would be the first 2 steps for most places. Also doing training for staff and frontline staff for confidentiality policies is worthless if no one who works at the agency doesn't, or, the organization is not aware of it. Also, thinking of ways in which you can also create sort of safe spaces, thinking about actually where you hold programs and having them in in places that are covered by the sensitive location memo is another thing. Maybe move that meal program into a church. Maybe think about, what are safer places for people to access the kinds of services and programs. And as we move forward, thinking about, I think we're going to have a lot of hard thinking to do about, if DACA ends, how we can, look to create state and local solutions to the benefits and crucial resources that people are going to be cut off from when they leave DACA. Great.
Thank you so much for that additional answer to that important question. I'm not sure which of you could answer this question better, but it's a good follow-up question to your what you were just suggesting around moving programs such as food pantries into some of those locations that are covered by the sensitive locations policy, such as churches. So Emmanuel Adero asked, is the sensitive locations policy binding or just a guideline for ICE? And have they enforced in these locations recently or since the policy was established? I don't know which one of you might want to take a stab at that question.
This is Wendy. I was just going to say, so it is actually guidance for ICE. I mean, that's one of the reasons, and technically ICE has some discretion in extenuating circumstances to enter a sensitive location. We of course ask folks to report any violations where there hasn't been an extenuating circumstance in which ICE has entered a sensitive location, as we're trying to document those as well. And I think it's also important to note that that's one of the reasons why we're trying to move forward with federal legislation that would actually codify the sensitive locations policy. And maybe Jackie wants to add to that as well.
Yeah, I mean, I think we need to be honest with folks. There have been violations of the sensitive locations policy, or de facto violations like arresting people right outside of schools, or ICE routinely lies. They'll call someone and pretend to be their cousin when they're inside a church service and say that their cousin's been in an accident and arrest them outside the church. I think it's important that we be honest about that. That said, I think similar to my earlier message around sort of that we have to kind of push back, or we're doing, the work for the administration of cutting immigrants off of benefits, that we are all safer if we really try and ensure that we maintain sensitive locations as safe spaces, and that we, really push back and send the message that these are safe spaces. Otherwise, they will become unsafe spaces. So.
Great, thank you. So I just wanted to, we have another question which I want to make sure to answer, and I want to just give people a few more minutes to answer questions. We have another 6 minutes or so of the webinar. And also wanted to just reiterate that this is part of a larger series of calls related to children and immigrant families, and encourage people who haven't already looked at them. I believe all these webinars were recorded. Some of them were on issues that touch upon things we've talked about, such as partnering with immigrants organizations, communications, data, et cetera. And we'll also be trying to make sure that some good accompanying information gets up on the Advocacy Learning Lab, which is a great resource. It already includes a lot of information relevant to this topic. And also encourage people to use KidsNet to share information with one another in a kind of peer learning way, and to reach out to organizations like those on the phone on this webinar who might be able to provide technical assistance. So in that vein, I'm just going to ask this last question that's up, but please feel free to ask any more if you have, we still have a few more minutes. Laura Spear has asked, if folks are not already connected, can you give us some guidance on ways to make connections with organizations representing immigrant families in states and localities?
I mean, joining the Protecting Immigrant Families campaign is one, for sure. I don't know, Wendy, if you have other suggestions.
I think I was actually going to say the same thing. One of the things we're trying to do is foster those types of connections at the state level. And so, yeah, if you were, if for whatever reason you weren't able to actually participate as even just an ally in the campaign, you could get in touch with me and Jackie, and we can most likely help make those connections with an immigrant rights group at the state level.
Great. All right, well, if anyone has a last-minute question, feel free to post it right now, but otherwise I will wrap up. This was a call chock full of information from both presenters, and hopefully people will find the slides and the recording a useful resource as they prepare for the release of the Race for Results report and for other work they'll be doing in their state. And I hope we'll all continue the conversation online. And thanks so much both to Wendy and Jackie for all of the great information, and to all of you on the call. One last question before we sign off. I think maybe there was a little bit of information on the last slide, which we might be able to go back to, which was how do we sign on to the Protecting Immigrant Families campaign?
So you can email co-chairs at protectingimmigrantfamilies.org, and we just got the link up this week for people to sign on, or you can email me or vmo@nulc.org, or Wendy, do you want to give your email?
Sure, and mine's on one of the previous slides too, but it's wcervantes@clasp.org.
Great. Well, I think that's a great way to end the call. And again, thank you to everybody, and please continue the conversation and the good work. And we'll all talk to you soon. Have a good afternoon.
Thanks.